Now let's talk about company administration in Nigeria and why directors and stakeholders should embrace court-ordered restructuring and not resist it. And we have Amala Umeke, founding partner, Strain and Bland Partners, to join us. Hi, Amala. Good afternoon and welcome to the program.
Good afternoon. Thank you very much for having me.
Good to have you. So it's a period of building trusts. So many disruptions going on. And yet, of course, businesses must strive for the economy to grow. So walk us through the mechanics briefly, how a company enters, deals with administration.
Yeah, thank you very much for that question. So essentially, you have to understand what sort of companies should enter into administration. It's distressed companies, right? So I see nowadays where people use administration as a tool for recovering bilateral debts. You have a bank or you have a creditor who has an issue with a company and then they go and put it on administration, whereas the company itself is not distressed. So first of all, it has to be a distressed company. Again, distressed in the sense that I still hope of recovery. So administration is not something, or cut all that turnaround and restructuring is not something that you use for companies that are essentially comatose, right? Those companies should be liquidated. There's nothing anybody can do about it. But yes, under the law, you would have basically two routes. Obviously, there are, it's just a general statement. There are other ways you can do it, but you either go to the court and ask the court to appoint an administrator, and very importantly, someone who is independent and expert with the requisite skills to turn around and restructure companies, or at least bring in consultants and experts that can do that. And then the other one is appointment out of the court, essentially either through the directors or holders of floating charge. And the interesting thing is the sort of benefits that you then get when the company goes into administration. Remember that this is typically a company that is distressed. There would be a lot of lawsuits against them. The accounts of the company may have been frozen. Once that company goes into that process and has an independent person come in under the supervision of whether it's the court or, because once you're appointed, you become an officer of the court. Essentially, there's a moratorium, there's a protection that is offered by the law. You can't go after the company again. The assets of the company becomes preserved in order to give that breathing space needed to turn around that company, essentially. So, this is perhaps a bird's eye view of the process and how it works.
But despite the protective framework offered by administration, we know that in practice, the resistance to administration can be fierce from directors, shareholders, creditors. So why is that?
Yeah, I think essentially it will come from historical antecedents. So administration is actually something that's very new, right? It's something that started under the Companies and Allied Matters Act 2020. The regulations came out in 2022. It's not very popular yet. Historically, what everybody knew is liquidation receivership. So there's the trauma that comes with it, right? Once somebody is appointed, because personally, I don't actually like the word administrator because it has this coercive undertone around it, right? I would have thought that just like in South Africa, we might have business rescue or chief restructuring officer. But that's by the way. I agree with you, and that is something that plays out in practice. There's a lot of fierce resistance from the various stakeholders, from directors. And okay, let's break it down. Starting from the directors, you have an independent person. You don't even know the person. The person comes into your company, and I keep saying that the concept of distinct personality when it comes to corporate law in Nigeria is a myth, right? The directors believe they are the company, so they are the only ones that should be able to run it. So there are historical traumas around that. The other part that you have to look at, which is something I personally see a lot in practice, is that, again, when people say that there's corporate governance in Nigeria, my theory is that less than 20% of companies in Nigeria practice corporate governance. So there's a lot of self-interest, there's a lot of self-dealing that goes on in these companies. You have directors who are flying private jets, using funds and resources of these companies to fritter away. So they don't want somebody independent coming in, right? I'm dealing with one now that I know that, just when we came in, there were some seeming diversion of funds, right? So these are things that would motivate a director to say, oh, I don't want someone who I don't know, an independent person coming in to say he wants to turn around and he or she wants to turn around and restructure the company, but he's going to look at my books and he's going to see all the things I've actually committed. So those are some of the reasons why, in practice, I see or we see some of the resistance that we face. The one that actually really baffles me is then the creditors, right? Again, it's a product of ignorance, right? You see in certain instances, right, which is quite surprising, where creditors will then fight the process. And again, it comes from a position of ignorance that people think, oh, just like in receivership, I want to be the person to appoint the administrator. Whereas in reality, if we practice it right, really, the person who is the appointed administrator is an independent person who is acting on behalf of all the creditors. And so there's the belief that, oh, if I pursue a bilateral recovery means, I will be able to get more money for myself. And in reality, that's not true. So you see a lot of resistance, a lot of fight, and which is why people like us are now taking it upon ourselves to see how we can educate the public to say, look, this is only but a restructuring. This is only but a judicial process that allows a turnaround of this company for the betterment of the company and for the betterment of the society. You don't need to resist it. If you understand this, you should understand as a director, you will be the one to embrace it.
Yeah, but this perspective and resistance, is it just a Nigerian thing?
Well, I would say that, again, I'm being careful how I say it, right? But in jurisdictions such as in the UK, it's been there, right, for long. In South Africa, for instance, the business rescue provision that they have has been there for long. And so it also stems from the cultural issues that we have. We have a culture, and which is quite sad, where as companies, you'll be drowning in debt. You have creditors who are at your door chasing you around, trying to seize your assets. And yet, out of perhaps misguided pride, you are still saying, oh, I still want to be the person running this company. I don't want to seek any professional help. In the early days when we started this business of turnaround and restructuring, when we talk to companies, they will tell you, oh, no, what we need is extra money. We just need extra line of credit. Can the investment bankers help us get this extra line of funds in order to continue? Whereas you haven't solved the underlying issue. So I would say that you wouldn't see that much outside Nigeria. In fact, in England, what is even interesting is that it is companies that request to go into administration. In South Africa, it is companies that will request to go into business rescue. In the US, under their Chapter 11 bankruptcy, it is companies that request that. But in Nigeria, we have a cultural issue, which hopefully, with education, people will get to retool how they think, which is that.
So do you think that perhaps a structural change at the policy level could accelerate this adoption and change in perspective?
Yes, I think so. I think that, not just the laws, but in terms of how the judiciary supports the system, there would be some level of changes. There should be a retooling. We think that even regulators, so even when it comes to tax, right, that regulators should embrace a restructuring mechanism rather than chasing around companies to distrain them, to close them, to close them down. If there is that change from an institutional perspective, things will go better.
All right, Mr. Malo-Omeke, thank you so much for bringing that to a notice, and hopefully we'll see more adoption. Founder, partners, Strain and Bland Partners, thank you for your thoughts and your time.
Thank you very much.